Okay, guys, welcome back. We're right back into it. It's another edition of Lawyered Up. Carla Ransom posted in the chat before we begin, why did you not post the appeal hearing being denied? And I put a link to our website post. Now, the reason I didn't do a Lawyered Up just on that is because it would have been a really short Lawyered Up. It would have just been like, well, the appeal got denied. I was kind of waiting until some of the more of this stuff got piled up so I could cover everything. So my apologies for that. We did do coverage on it. I just didn't do a Lawyered Up at the time that happened, if that clarifies everything. Okay, so the developments, and I'm going to go ahead and pop the computer up for you guys right now, and we can just start going through everything. First off, I wanted to talk about the major things that have happened, and I'm going to be... Chief Hill posted an executive order today. We have a link to it on our Facebook if you want to go read it. But essentially the executive order says, you know, we're going to wait and we're going to establish some procedures in order to take Article 2 of the 1866 treaty as the method to comply with the Supreme Court's order. But it's going to take us some time to develop those procedures. And yesterday on some Freedmen groups' Facebook posts, they were showing that they had filed for a motion for contempt in the Grayson-Kennedy case. Now, I was waiting for the MCN Supreme Court's website to update with the information before we went live so I could show it to you guys. But, I'm sorry. Hold on. There's one thing I wanted to show you before we get into that, and that's this. First off, you may notice that the Supreme Court's website looks totally different. So they updated their website, and also, this is something that I talked about before. They've updated their Constitution to be correct because you'll see here down at the bottom that now we have, finally, after so many years, the Article 14 independent free press is added to the Constitution on the Supreme Court's website. So they finally have that independent free press stuff in there. Okay, so now back to what I was saying. Chief's executive order, please post Chief Hill's Okay, David, you need to go to our Facebook. That's where it is. I can put it in the description of the video afterwards, or maybe I could post it into the chat. Just give me 1 second. Let me go through the filings here, and then I'll get you a copy of that into the chat, David, if you haven't seen it. Okay, so the two things we're going to be looking at here are down here. Is that big enough? Can you guys see that? That's better. So the first one is this one, Respondent's Motion for Contempt and for Enforcement of Order and Judgment. So let's take a look. Boop, boop, doo, 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 doo. This can go away. All right. So basically what this is a motion filed by Solomon Simmons and Jana Knott, etc., requesting that the Citizenship Board be held in contempt for not complying with the order that the Supreme Court issued. This court ordered the Citizenship Board to do one simple thing, issue citizenship to the respondents. More than a month later, it has still not, even as this nation's election deadlines are rapidly approaching. Because of that failure, Mrs. Grayson and Mr. Kennedy hereby move to hold Citizenship Board in contempt pursuant to MCN Rules of Procedure 20C, etc. Okay, so that got filed, if we look up here, on the 27th. All right, so let's go back and look at, then this was issued on the 28th, which is the order denying respondent's motion for contempt and for enforcement of order and judgment. Okay, so I'm going to read this because we're going to go through this. On July 23rd, 2025, the court issued its order and opinion, finding in part, and I'm sorry, I should preface this by saying this is the Supreme Court talking. That's who issued this. So on July 23rd, 2025, this court issued its order and opinion, finding in part that the appellate acted contrary to law when it failed to apply Article 2 of the Treaty of 1866 and denied the respondent's application for citizenship solely for failure to trace a lineal descendant on the Creek by Blood Dawes roll. Okay. Subsequently, on August 4th, the appellant filed its petition for rehearing, the last remedy available to a party in an appellate action pursuant to the court's rules of appellate procedure, effectively staying enforcement of the court's order and opinion until a decision on the petition was rendered. On August 20th, 2025, this court issued its order denying appellant's petition for rehearing, finalizing the above-styled appellate action. Neither this court's order and opinion nor its subsequent order denying petition for rehearing directed the appellant to process the respondent's citizenship applications by a date certain, nor did it guarantee this task would be completed in time for respondents or other similarly situated applicants to participate in the 2025 Mvskoke Creek Nation election cycle. This court understands the respondent's excitement to participate in official Mvskoke exercises of citizenship, but it also understands that its decision represents a significant change in the appellant's policies and procedures, that it may take a reasonable amount of time to establish appropriate changes to the appellant's internal policies in order to fairly and lawfully process respondents and other similarly situated applicants' citizenship applications. Only 1 week has passed since this court issued its order denying appellate's petition for rehearing. This court is not inclined to consider contempt or other Rule 20 penalties at this time. It is hereby ordered that the respondent's August 27, 2025 motion for contempt and for court enforcement of order and judgment is denied for the reasons explained above. Okay, so there we go, guys. This is pretty much where we're at, and I kind of mentioned some of the stuff that the court mentioned here when we did our previous Lawyered Up, to say that the order and opinion of the court doesn't designate a time frame for when Grayson or Kennedy will get their citizenship cards, so we don't know when it's going to happen, right? Now, if the court had ordered it to be within 90 days or whatever, that clock is going to actually start ticking after their last filing in the case, whereas their denial of the rehearing, right? That's what the court is saying, is that the clock actually starts for this contempt motion thing after the order for the denial of the rehearing. Okay, there's a lot of stuff in the chat here. I'm gonna look at this really quick and see if there's any questions I can answer. Does it mean they will not go to... Okay, so Abilove is asking, does it mean they will not go to the federal court? Well, to answer that question, let me see if I can get Chief's executive order here. I think we have it on our Facebook, but I don't... Let me look and see if I can get the actual thing here. No. Here we go. This is what I'm looking for. Okay. Boop. Oh, we got it. Okay, let's take a look at it. So Abilove is basically asking, I think, does the executive order, is that chief saying, hey, we're working on these processes, we're not going to pursue any more legal actions, right? We're going to fix the processes and we're going to comply with the Supreme Court. Okay, so let's read it and find out. And this was issued today. So, 1, findings on July, well, I'm going to skip over some of this because we just read this. So, it says 1.3, as principal chief and every elected officer and every judge and justice of this nation took an oath to uphold the Constitution of Mvskoke Creek Nation, and the nation's Supreme Court has previously held the Constitution supreme law of the land. And then, he's going through catching us up to where we are. Okay, let's go down here to authority action. The office of principal chief hereby declares and directs the Citizenship Office to continue accepting applications from the Freedmen descendant applicants, but not issue citizenship cards or any form of membership identification cards to such persons until all law and policy have been fully reviewed and amended to meet the qualification requirements under Article 2 of the Treaty of 1866. Okay. 2. The Office of Principal Chief further declares and directs the Citizenship Office to maintain the status quo by continuing to accept process and issued determinations for applications for new Mvskoke citizens in accordance with current law and policy. So I had this question earlier. A citizen sent me a message saying, does this executive order freeze everything? No, he's saying that everybody else who's not using the Freedmen rules as their justification for citizenship will continue to get that we're going to operate under the laws we have in place right now. We're just freezing those the applications that use the Freedmen rule so that we can get the proper policies and procedures in place. Okay, so let's keep going. All right, let's see here. When the necessary reviews are complete, we will follow the normal processes established by the executive branch to review and approve prior to the setting forth the adoption of changes. Where necessary changes require National Council approval, each department will submit those changes to the Office of Principal Chief in accordance with established procedures, and the Principal Chief will submit the changes to the National Council for its review and approval. Okay, so my interpretation of that is that Chief is saying each department that this Supreme Court ruling affects is going to tell the Chief's office that this is how it affects us, and Chief's office is going to present some type of legislation to the council or work with the council to develop that legislation to address that particular instance, and then they will pass it, and then we'll move on to the next thing. That's how I interpret that. Let's go back, and where necessary changes... Oh, we did that? Copies of this executive order. Okay, so we've covered it. All right. Now, let me scroll through here and see what we got. Sorry, guys. I've got to catch up with the chat. What would you say at the Oregon? Okay, so do the Freedmen meet the definition of Indian federal? I don't know if you're asking me that question or TY Prol. I see your last question there in the chat. So I guess the question you guys are discussing is this going to be pursued to the federal court? I don't know. Chief hasn't said that. I will tell everybody who's advocating that this goes to federal court that you need to look at the federal court's decisions in the Cherokee Freedmen situation, because they're going to dictate how the federal court rules in this situation. And the 25th Circuit ruled in their case, and it didn't go the way that you thought it would go. Or, well, that was the pivotal ruling in that case. So you need to look at that precedent, because that's going to determine how the federal court rules. And the federal court didn't rule in terms of in favor of the Cherokee Nation Constitution. And in fact, in the filings on McGirt, there was a case that was referenced. I don't know the name of it off the top of my head, but it was a case that the United States Supreme Court heard against the Cherokee Nation, because after their 1866 treaty, and granted, it's not exactly the same situation, but the Cherokee Nation, after they had their 1866 treaty, they amended their constitution to exclude freedmen. And in 1889 or so, there was a case that went to the U.S. Supreme Court where they said, no, you guys can't amend your constitution to change the terms of your treaty. You can have a constitution, but it has to comply with your already agreed upon terms. So I'll just leave that with you guys. And if you want to hunt that case out, it's in the McGirt filings. I don't remember the name of it off the top of my head, but I think it's USA versus Cherokee Nation or something like that. Okay, so let's see here. The Graham versus Holland case. I just checked it today, and what it says is the stay is still in place that Graham wanted in November. So I don't think that's gonna get lifted. And it's possible. Tulsi Town is saying Graham withdrew his case in federal court. That's also possible, because that would be why they wanted to have the stay in the first place. Is they wanted to have their case heard with the MCN Supreme Courts precedent in place. And because the Supreme Court ruled in the way that it did, if Graham continued to pursue his case against the DOI or Holland or whoever, in the federal side, or the Creek Nation, it would be for some type of damages or something like that, right? To achieve it, to get a settlement. And there is a possibility that because they won at the Freedmen won at the Supreme Court, he doesn't feel that he needs to spend more money pursuing that case, right? So he could have said, no, I want to shut that down. T.Y. Pearl, the federal government approved our Constitution, unlike the Cherokee Constitution, correct. T.Y. Pearl, the federal government did not approve our Constitution. The executive branch of the federal government approved our Constitution, but our Constitution was never reviewed by Congress. So that was part of the arguments in the oral arguments of the Freedmen case before our Supreme Court. I would go back and I would check that and see, because that argument had a lot of impact with our Supreme Court justices to say that the BIA's approval of tribal constitutions is an executive branch action. It doesn't get reviewed by United States Congress. It doesn't get approved by United States Congress. Now, the only thing that can be changed what gets changed by United States Congress is the treaty, right? So that was the basic argument, is to say that the only way you can abrogate a treaty is to have the United States Congress pass a law and have the President of the United States sign it, that they're going to abrogate the treaty. Whereas the approval of a tribal constitution only goes through a cabinet in the president's, in the executive branch of the government, right? So the treaty requires two branches of government to agree. The BIA only requires one branch of government. Do you guys see that? So I'm just taking a look here per the Supreme Court ruling. Yeah. Okay. Now, I had some requests to do some updates on some other cases, one of them being Hauser. You guys may remember the Hauser case as the guy who worked in the casino's payment office that embezzled over a period of 10 years, something like $20 million or whatever it was. We did a previous lawyered up on it. So that case, he confessed and cut a deal. There hasn't been anything happen yet other than the pre-investigation report, which is sealed, and I can't see that, has been turned in, and the federal prosecutor made a motion to reduce his federal sentencing guidelines by 1 point. And they did that, they made that motion because he cooperated and confessed and everything. So now that motion hasn't been granted, but I expect that it will be granted, because why wouldn't it be granted? The federal government's making the motion, and it's probably part of his plea deal. So the update with Hauser is there's not really that much of an update. We'll see what happens. We haven't gotten to sentencing with him yet. And then also there's another case before the Supreme Court that I had a request to take a look at. So I'm going to take a look at it now. But it is in the open cases. Let me pop this up. Sorry, guys. So we go to open cases on the Supreme Court's website, and you'll see down here, Big Elk Energy Systems versus One Fire Holding Company. So we're going to pop this open and take a look here. I'm going to start off with the brief of appellants. So this is a brief that's filed by this company, Big Elk. And they're going to tell us from their perspective, what happened first. Let me scroll down here. Sorry, guys. Introduction. Okay, so let's try to find out what's going on from this case from the first filing. This appeal arises from Mvskoke Creek Nation District Court's entry of a sweeping default judgment against defendants Big Elk Energy Systems and Jeffrey Hager without notice, without hearing, and during the time in which defendants were entitled to respond. The judgment awarded over $2.5 million in damages, injunctive relief, and attorney fees, all without affording defendants a meaningful opportunity to be heard or to oppose the relief sought. Plaintiff One Fire Holding Company initiated the action based on disputed rights under a company operating agreement, and defendants promptly moved to dismiss. Although the district court denied the motion, defendants subsequently mailed their answer in accordance with the scheduling order. Unbeknownst to defendants, that answer was not docketed, and plaintiff then sought default judgment based on the absence of a timely response. The procedural path that followed reflects a series of serious irregularities. The order setting the hearing on the motion for default was never entered on the appearance docket. The court relied on an incorrect motion filing date. The district court then denied the defendant's motion to vacate without a hearing and without addressing the material defects identified. These actions deprived defendants of due process as guaranteed under the Mvskoke Creek Nation Constitution and procedural rules. Okay, so that was a filing by Big Elk, and they're saying, hey, we had this action filed against us by One Fire, and we made these filings, but we weren't told that it was going to get heard in court, et cetera, and because of that, there was a default judgment against us, and so they want this to be reviewed. Okay, I'm going to go to the next filing. This is the respondent's brief. Now, this case hasn't been decided, as we see there in the stuff. So I'm just going through both sides. So, statement of the case. Now, this is let me make sure what I'm reading here. Yes, this is One Fire's response to Big Elk. Appellate's argument rests entirely on 3 false assertions contained in the first sentence of their opening brief: that the district court entered its order for default judgment without notice, without a hearing, and during the time in which defendants were still entitled to respond. To the contrary, the record reflects that appellants received notice of both respondents' motion for default judgment and the district court's order for show cause hearing. Additionally, the district court did, in fact, hold a hearing on August 26, 2024. Appellants, despite receiving notice of the hearing, did not attend. Finally, appellants offer no legal support for the assertion that the district court ruled within the time appellants were entitled to respond. To the contrary, the assertion is in direct conflict with the rules and procedures of the Mvskoke Creek Nation Tribal Courts, which provide written motions in all matters will be heard at the next regularly scheduled court session after filing in service, but not sooner than 5 days after filing in service. As filing in service of One Fire's motion for default judgment was completed on August 6th, the court was empowered to set a hearing on such motion on or after August 13th, 2024. Here, the court waited for nearly an additional 2 weeks beyond what was required in setting the hearing for August 26, 2024. Appellates had ample opportunity to respond and or appear, yet failed to do so. Accordingly, the district court's entry of default judgment should be upheld. So, sorry, I didn't have all that. I screwed up. So that wasn't on the screen, but trust me, that's what's written in there, and you guys can go to the Supreme Court's website and read it. But in a nutshell, basically, one side is saying that the procedures were violated and they shouldn't have a default judgment, and then the other side, One Fire, is saying, no, you guys, the court followed all the rules, you guys need to pay your money. And so we don't have a decision in this case yet, as you see here. And when it happens, so it was requested that I do some coverage on this. So that there we go. That's my explanation of what's going on in that case, and we'll see what happens with the decision. Okay, what else? I think that's it, guys. Let me take a look at the chat and see if there's anything in here that I need to get involved with, because you guys are having a heated conversation here. It's still nice. Congress didn't rule against hearing on. Okay, let's see here. Can you do a what is or lawyered up on the Freedmen's failed attempt to be federally recognized as a tribal town? Why were they denied? Okay, T.Y. Prohl's asking that question. I myself don't know anything about that. If a tribe applies for that, I'm still trying to figure out where I can go to get that information at the BIA, I guess. I'd have to file a Freedom of Information Act to get that side of it. T.Y. Prohl asks, can you provide a link to previous MM coverage of Big Elk? This isn't the first controversy with them. I don't know if it is or not the first controversy with them. We did do a video from I think it was 2017, when I think what happened with them is, I'm not for sure, don't hold me to this, but I think One Fire did some type of funding agreement with them with the understanding that that the Creek Nation would have a controlling interest on their board and get a percentage of their profits. And I think that's what the dispute is in this, that they got the default judgment. In fact, let's take a look at that, because I think that's in here. Let me look at that, and then we're not going on my recollection. We're going on what they filed in court. Hold on, let me see if I can find that for you guys real quick. Let's see if they talk about the. Here we go. Okay, this is what I'm looking at. So this is this is Big Elk that's saying this. This isn't One Fire. So plaintiff One Fire Holding Company commenced this action by filing his complaint on August 14th. Appellant Big Elk Energy Systems is a manufacturer and designer of equipment for the natural gas industry, and appellant Jeffrey Hager serves as its manager. One Fire is a limited liability company organized under the laws of the Mvskoke Creek Nation and is one of several ownership unit holders in Big Elk, holding one of 5 seats on the company's board of managers. Okay, so right there. In 2017, I think it was, we did a video about Big Elk when this was started, right? So to say One Fire is working with these guys and this is a look at their business, so economic development type story. It's on our YouTube channel. If you search Big Elk, you can watch it. But going back to the filing. Upon joining Big Elk, One Fire and other members executed an operating agreement governing, among other things, the distribution of available funds, which are subject to the discretion of the manager. The dispute in this case centers on the interpretation and application of that operating agreement, specifically the contractual limitations on making payments or distributions at the amount demanded by One Fire. So what they're saying there is, once One Fire, which is Creek Nation, got on their board, we renegotiated an operating agreement that gives us a percentage of the operating money, right? And there was some dispute about how much money the Creek Nation should or shouldn't get, right? Okay, let's keep going. On September 21st, 2023, defendants jointly moved to dismiss the complaint. The district court denied the motion on May 23rd, 2024. So now we're into the actual court case. So there's the explanation from Big Elk's side of what One Fire was involved with them in and everything. And that's also kind of like I think our video was when they did that deal originally and the Creek Nation got involved, it was kind of like to take a look at what Big Elk was. Let me take a look here and see. Can you probably link to previous coverage of Big Elk? Keystone Pipeline. They provided the pipeline. The water protectors were protesting. Oh, is that? I didn't know that. You haven't told us anything about the Freedmen case that we don't already know. Yes. You guys probably know. David, you probably know everything about it that I just told. I just wanted to get a lawyered up update happening, because this is what the documents that were officially posted on the MCN Supreme Court's website. So typically when we do news gathering, I don't personally like to report on when people post court documents to their Facebook page, because there's a possibility that those court documents aren't real. I try to get them from the court, and I did email the court clerk, Connie Dearman, today to try to get those documents, but before I got a response from her, they just posted it on their website. So that's the sequence of events there. So sorry if you guys saw it before me, but that's happened sometimes. I've got to make sure that it's real. Is there a blood quantum restriction to serve on the One Fire board? That I don't know, TY Pro. All right, guys. Well, we got that done. It's about 30 minutes. Sorry if I was talking really fast and didn't get to the things that you wanted me to get to. And again, I didn't say it at the start, but I am not a lawyer. I'm just like you guys, unless you guys are lawyers, but I'm just a regular Joe. And so a lot of this stuff I don't understand that well myself, and I'm just trying to get the information out there. I did want to take a second to applaud the Supreme Court on their new website. I like it. It looks good. I'm so happy that the Constitution got updated. T.Y. Pearl's asking, did you see the National Council allocated funds to pursue the Strobel case to SCOTUS? Thank you for mentioning that, because yes, and we have coverage on our website, that's MvskokeMedia.com, where we talk about that funds. But basically, if you guys have been following Lawyered Up, you'll remember the Strobel case, which went up to the Oklahoma Supreme Court, and that was about the income tax, a citizen who worked for the government who was trying to use Oklahoma tax code that was on the books that said she didn't have to pay income tax on her money that she's paid by the government as her job. And the Oklahoma Supreme Court said she was not eligible for that exemption. And so it looks like there's been money passed through council to pay some lawyers to pursue that up to the federal level, and we'll see what happens with that. So there we are. I appreciate you guys. Thanks for tuning in. It's been a heck of a night tonight, and I really enjoy all of you guys coming in to the chat and having a spirited discussion. I would say let's try to keep it civil and, don't go at each other too much. But with that being said, I am going to punch out for tonight. Rodney Josie is asking, are there any time frames you are aware of RMFIR citizenship to figure this out? Oh, you asked about how long, Rodney, it looks like you're asking how long this is going to take for the Grayson-Kennedy to get their citizenship cards, right? Or how long is it going to take them to establish the procedures? We don't have any idea, right? And this is just my opinion, or we can assume that they're not going to make it by September 9th. And by the way, September 9th is the deadline to register to vote. So they're not going to be able to register to vote in this election. And then if they're not going to be able to register to vote in this election, this is just my opinion as an observer of the situation. I would like to see them take their time so we can get it right this time. Because my worry with all of this is the Citizenship Board and the executive branch appear to be trying to comply with the Supreme Court's order. And if we do it too fast, or if they do it and there's a mistake, right, we're going to see more cases that'll go up to the Supreme Court, and we'll have to go through this whole process. And that could happen anyway. But the more time that we take and the more public discussion that's had about this issue, the better we're going to have as far as complying with the Supreme Court's order, if that's what we're trying to do. Now, there's also a possibility that it's going to go up to federal level, but it's not looking that way, but we'll see what happens. It could, if you guys are out there watching and you want to keep right on the knife edge of what's going to happen with that, we post council coverage to our website and in the paper after the council meetings. And you can go, the National Council has a website, you can go and watch the council meetings. So the committee meetings, well, let me give you guys just a little explanation real quick. So legislation's got to go through the committees, and then once it makes it out of the committees, it'll go to the full council. And then if they vote it in, it's got to go to chief and it gets signed. And if there is going to be a case at the federal level, there'll need to be the money to pay the lawyers to pursue that case is going to need to go through the committee meetings, and then it'll go through the council, and then chief will sign it, and that'll happen. So if you see, and the legislation should say that we're allocating this money to pursue this, just like we're talking about with the Strobel case. So I would expect it, if they are going to pursue that federal option, that we'd see some money go through, and it would probably be Conji or one of those law firms that we used in the past on the case. So we'll see what happens. And once again, thanks for tuning in tonight, guys, and I'll see you later. Mado hadom, chihichat, please.